What is agency? Agency is a relation between two or more persons by which one party, usually called the agent or attorney, is authorized to do certain acts for or in relation to the rights or property of the other party, who is denominated as the principal, constituent, or employer. The creation of agency, when expressed, may be either by deed, in writing not by deed, or by a verbal delegation of authority. When agency is not expressed, it may be inferred from the relation of the parties and the nature of the employment without proof of any express appointment. In most of the ordinary transactions of business, the agency is either conferred verbally or is implied from circumstances, but where the act is required to be done in the name of the principal by deed, the authority to the agent must also be by deed, unless the principal be present and verbally or impliedly authorize the agent to fix his name to the deed. The authority may be general when it extends to all acts connected with a particular business or employment, or special when it is confined to a single act. If the powers are special, they form the limits of the authority. If general, they will be more liberally construed according to the necessities of the occasion and the course of the transaction. The agency must be antecedently given or subsequently adopted, and in the latter case there must be an act of recognition or an acquiescence in the act of the agent from which a recognition may be fairly implied. The business of the agency may concern either the property of the principal, of a third person, of the principal and the third person, or of the principal and the agent, but must not relate solely to the business of the agent. A contract in relation to an illegal or immoral transaction cannot be the foundation of a legal agency. The termination of the agency may be by a countermand of authority on the part of the principal, at the mere will of the principal, and this countermand may, in general, be effected at any time before the contract is completed. Even though there may be an express agreement not to revoke, but when the authority or power is coupled with an interest, or when it is given for a valuable consideration, or when it is a part of a security, then unless there is an express stipulation that it shall be revocable, it cannot be revoked. When the authority has been partially executed by the agent, if it admit to severance, or of being revoked as to the part which is unexecuted, it may be revoked as to that part, but if it is not thus severable, and the agent by its execution in part will sustain damage, it cannot be revoked as to the unexecuted part, unless the agent be fully indemnified. This revocation may be a formal declaration publicly made known by an informal writing, or by parole, or may be implied from circumstances as if another person be appointed to the same act. It takes effect from the time it is made known and not before, both as regards the agent and the third persons. The determination may be by the renunciation of the agent either before or after a part of the authority is executed. It should be observed, however, that if the renunciation be made after the authority has been partly executed, the agent by renouncing it becomes liable for the damages which may thereby be sustained by his principal. And the agency may terminate by the expiration of the period during which it was to exist and to have effect, as if an agency be created to endure a year or until the happening of a contingency. It becomes extinct at the end of the year or on the happening of the contingency.